Is there anyone else here to speak on this issue? Mr. Hoeschler, welcome back.
Thank you very much. My remarks, of course, as the predecessor remarks, would go to all four issues that are coming up. Basically, I'm here to try to focus the council's attention on the law that has evolved since I started challenging these matters back in 2011. So the fact of the matter is the Minnesota Supreme Court and now the District Court, Judge Noecker, has repeated that the key question for the city to look at is what is the purpose of this expenditure? What is the purpose of this charge? And if the purpose of this charge is to regulate behavior on the part of the residents, then there could be a legitimate fee associated with that. But if the purpose of this charge is to raise revenue, and I think that that's what it is, and we're all faced with this problem because we all recognize we have a significant street repair problem, we have a significant problem of paying for the street repair. If the purpose of this is to raise revenue, then it can only be done by regular taxes or as a special assessment if you can show that there's a special benefit involved. And in this case, we have presented in the past, and for the past 8 years, we have presented opinions of professional appraiser to the effect that there is no special benefit. There is a general benefit. There's no question there's a general benefit about improving the streets, but no special benefit. The city has been unable to come up with any appraiser who agrees with its position. The city, failing to come up with an appraisal that would show special benefit, then changed its theory and argued that this could be a fee. And it was that the Supreme Court overruled and said, no, it's not a fee. This is clearly a revenue-raising issue, and it's clearly something that has to be dealt with under the rules of the tax law. In the case that is before us today, we have these residents along arterial streets that are clearly intended to be and are designed to be servicing the entire metropolitan area. And these poor unlucky souls, Mr. Taghioff is of course one who happens to have the long side of his lot along one of these arterial streets. These unlucky souls are in fact paying a substantially disproportionate share of the costs of maintaining the system because of that situation. But the main thing is that they are paying a fee that is not justified by any special benefit to their property. And that's what, this is really the Ferguson effect. Ferguson, Missouri, of course, is notorious for funding its city budget on the basis of fees and fines. And I think that this needs to be thought about by the council here. You don't want to be in that situation. You don't want to be in a situation where you know that you do not have any professional appraiser who can support your position. In light of that, I am here to ask you to ask for a legal opinion because you are naked. You're naked both politically and legally because you are in a situation where you do not have any defense for our challenge. And I'm asking you, I'm suggesting to you that you should be asking for a legal opinion, a written legal opinion from your city attorney or from the Attorney General as to whether you have a better than likely chance of winning against our appeal. In the past, every time we've been able to push it all the way to trial, the city has in fact caved in and given us a refund. But your staff continues to insist that the taxpayers should sue us in order to get a refund. And this business of sue me if you don't like it is just not the right way for a body like this to be dealing with people. In light of the fact that this has been going on for so long, my new pleadings are asking for the imposition of attorney's fees under the Ku Klux Klan Act. The Ku Klux Klan Act, 42 U.S.C. 1983, is a statute passed in Reconstruction times, 1871, to allow, in that case, black citizens, freed slaves, who had constitutional rights that were being inhibited and trammeled by recalcitrant, I might say, Democrats in the South. They were given a right to sue for damages and attorney's fees, the very people who, in fact, were depriving them of their constitutional rights. In this case, clearly under clear Minnesota law, a taking without special benefit is a taking without due process, a violation of the 14th Amendment. And so the point simply is there is a real possibility that I would be able to win a charge against you that you are proceeding in bad faith. Dare I say, even that this is starting to look like fraud, that you know you don't have either a legal opinion defending you, you don't have an appraiser's opinion defending you, and the court cases are quite clear that a fee theory doesn't work. And so what I suggest is that you table this action tonight and ask your city attorney for a written opinion. It's not enough to just get an assurance that we'll defend you. Surely they'll defend you. But the truth is, does the city attorney feel that it is more likely than not that you will prevail under these facts and circumstances and under the law in the case that we've developed over the years?
Mr. Hoeschler, I'm going to pause you there. Can we pause? The 4 minutes and 3 seconds are all yours.
Thank you very much. You and we are friends, and I consider you all associates and colleagues, and it is very difficult to be in a situation where we can only talk in court. For years, I have been frustrated by an inability to have a candid discussion with the city council members as to what should be done, what could be done about this. I have been frustrated by having initiated the Citizens League effort last year to look into ways for the city to receive pilot payments from the nonprofits. And indeed, I said to the city that the nonprofits are willing to pay more or less what they were paying before. The downtown churches didn't want to pay 5 times more than other churches, but the point is, generally speaking, the nonprofits were willing to pay. The city walked away from that procedure, and I think wrongly so, on the feeling that we can't rely on that because these nonprofits will have they'll change their mind one year after another. The proposal could have been and should have been that this is a commitment by the nonprofits for 5 years. Yes, we would let them out after 5 years, but they have to give a 5-year notice to the city if they wanted to get out of the pilot program. The city walked away. Now, that's not enough money to solve your problem, no question about it, but it was nevertheless a significant opportunity to bring everybody together and to try to help solve this problem. And so it has been a disappointment for me and for others. And Mr. Taghioff talks about the fact that he too would like to talk about different ideas and different approaches. But in this case, I'm here today to simply say, before you proceed further, before you give me a clean shot at you for proceeding in bad faith with knowing that you don't have a good defense, you should ask for your city attorney to give you a written opinion that will give you some protection, or it will give you a better understanding of the law. And if you haven't read Judge Noecker's opinion yet, it came down 10 days ago, you should. It's very helpful and instructive, and basically says the city's fee theory is nothing this time around for the street maintenance system work, is nothing more than a rehash of the old argument that the Supreme Court overruled in 2016. Thank you very much.
Thank you so much.